The wheels of justice turn. Donald Trump files an application with the United States Supreme Court to vacate the 11th Circuit Court of Appeals order, their motion for partial stay, returning classified records to the Department of Justice that Donald Trump stole and hid at the weird resort that he lives in. Then the 11th Circuit grants the Department of Justice's motion to expedite their overall appeal, challenging the hack judge, the Judge Eileen Cannon, who Donald Trump appointed in 2020, her order asserting jurisdiction, equitable jurisdiction over all matters relating to the search warrant executed at Mar-a-Lago. The October term of the Supreme Court has begun, and a critical Voting Rights Act case has already been heard. There's no ruling yet. The case is Merrill versus Melligan. We talked about it previously on the Legal AF podcast some months ago when the Supreme Court temporarily granted an emergency order that stopped a district court order that would have changed the maps. The Alabama gerrymandered maps were allowed to stay in place, and this was now the full hearing after the granting of the motion for cert on whether Alabama's gerrymandering was permissible or not permissible under the Voting Rights Act. And the Alabama Solicitor General made some really bold claims to try to undermine the entire Voting Rights Act Section 2. We'll talk about that more on the podcast. Also, Elon Musk claims that he is getting ready to settle with Twitter as he approached a trial date in the Delaware Chancery Court on October 17th. Is he playing games? Is this for real? He was getting destroyed in court. We will talk about that. And the January 6th committee is set to resume very shortly. We will talk about what we could expect there. I'm Ben Meiselas, joined by Karen Friedman, Agnifilo. This is Legal AF, the most consequential legal news. Michael Popak is out observing the holidays. Karen, how are you?
I'm good. I got my 5th booster yesterday and a flu shot all at the same time. So if I start to glow in the dark a little bit here during the podcast, that's why.
You don't glow in the dark, you glow generally. That is what people like to see, your glowing legal analysis. Let's get right into it with Donald Trump's application that he filed with the United States Supreme Court yesterday. This was an emergency application that's filed to vacate the 11th Circuit Court of Appeals order where they granted the Department of Justice's motion for partial stay regarding Judge Eileen Cannon asserting that she had equitable jurisdiction over the search warrant issues relating to the search warrant executed at Mar-a-Lago. Judge Eileen Cannon's order was overturned by the 11th Circuit as it related to those 100 classified records. The 11th Circuit permitted those records to be returned to the Department of Justice, as the Department of Justice argued. This is an emergency. We're going to be caused irreparable harm if we can't pursue our own criminal investigation regarding documents that belong to us. Donald Trump hasn't claimed a possessory ownership and he doesn't have one. He's a former president who stole stuff. You can't steal stuff, especially classified records, and then just say dibs and then you get it. This is the United States of America, and our national security is outlined. That didn't matter to Judge Eileen Cannon. It mattered to the 11th Circuit. The 11th Circuit was a 3-judge panel, 2 Trump appointees, 1 Obama appointee. They said, look, it's self-evident that the Department of Justice should have the documents back. They analyzed under a case called Ritchie and said every factor favors that the Department of Justice should have their records back. But nonetheless, Donald Trump has filed this emergency application to vacate what the 11th Circuit ruled, returning those records. And here's the unfortunate part, Karen. Clarence Thomas is the Supreme Court judge who has previously been assigned, so it's currently the allotted assignment that he has, to oversee emergency orders with respect to decisions reached by the 11th Circuit. So you actually, in weird Supreme Court procedure, which a lot of this stuff really hadn't been invoked, and we hadn't really heard about this so much until a lot of the recent machinations by MAGA Republicans, like utilizing these procedures and processes to undermine our democracy. But we talk a lot about it now. But Clarence Thomas ultimately oversees these emergency orders. Now, he on his own could make the decision to overturn or to vacate the 11th Circuit's order on an emergency basis. His decision, though, ultimately would be revisable or go in front of the entire Supreme Court. It would only be temporary if he makes that such a ruling vacating what the 11th Circuit did. He could also refer it out to the full Supreme Court to make a decision. He doesn't have to make it on his own. But what he's done, at least in the short term, is require the Department of Justice to respond by next Tuesday, 5 p.m. Eastern time. But the very fact that he's involved in this and his wife's an insurrectionist, and it just leaves a very bad taste in my mouth. Karen, what do you make of all of this, all of these machinations?
Yeah, look, there's a couple of things going on in this case right now at the same time. As you said, on Tuesday, Trump asked the Supreme Court to issue it's kind of a technical ruling saying that they should intervene because the 11th Circuit did not have jurisdiction to remove those classified documents from the special master's review. If you recall, there's lots and lots of documents, thousands of documents, but the Department of Justice appealed on a very limited basis, saying we just want to take away the 100 or 103 documents from the special master's review so that we can continue our investigation. And what Trump and then the special master can look at the other things and go on a rolling basis, is what Judge Deary, the special master, said he was going to do, and turn those remaining documents over on a rolling basis as he goes through them and as he makes a determination. But what Trump said was that not to overturn, in essence, the most important part of the 11th Circuit ruling, the decision that frees the Justice Department to continue using those 103 documents with classification markings. What they asked the court to rule by Tuesday at 5 p.m. was this very technical ruling saying that the 11th Circuit didn't have jurisdiction to remove those documents in the first place. So even if he wins this small, modest request, it's more his trying to delay, I think, because substantively he doesn't get much from that. I think the more significant thing that's happening in that case is the Department of Justice's full appeal. They originally, they just said, Judge Cannon, to the 11th Circuit, we're just saying Judge Cannon was wrong with the saying that the 103 classified documents, we can't have them. And the 11th Circuit, as you said, unanimously ruled on the side of the Department of Justice. But now the Department of Justice has filed their full appeal before the 11th Circuit. And that's the thing to watch. I think that's the more significant part of what's going on here. They're asking for an expedited consideration of their appeal, and I hopefully they will get it. But we'll see where that one goes. The whole thing with the special master really is a head scratcher for me because Donald Trump asks for the special master. The Department of Justice opposed the special master. Then they all submitted their names, put their names in a hat. Judge Deary was Donald Trump's pick. So what does Judge Cannon do? Judge Cannon bends over backwards, finds that she has equitable jurisdiction over the case, appoints the special master, and appoints Judge Deary, essentially giving Trump everything he wants. Well, Judge Deary, it turns out, didn't roll over the way Judge Cannon is rolling over for Trump. And so now all of a sudden, Judge Cannon is backtracking and saying, oh, well, Judge Deary, I'm not going to allow you to create the schedule. I'm not going to allow you to determine timing of when these things happen. I'm not going to let you turn over these documents on a rolling basis. And I'm not going to do anything the way you're suggesting, which begs the question, what do you need a special master for in the first place? I mean, this was what Trump wanted, and this is who Trump wanted. And so now Judge Cannon is saying, no, hold on, I'm going to do this. So that whole thing seems quite strange to me. But I think hopefully this will happen on an expedited basis. The 11th Circuit will allow the Department of Justice access to all the documents, and they can continue with their investigation. Of all the investigations that the Department of Justice is doing into Trump, I think this is the one that's furthest along and most ripe. And if he's going to, if heads are going to roll, I think it's going to be, in this case, certainly, it's certainly riper to me than the January 6th matter and the others.
Well, in many ways, too, it's a slam dunk in the sense of he stole records that didn't belong to him. We know the history and the timeline of even dating back to May of 2021. In terms of intent, Donald Trump was telling Mark Meadows to lie to other senior lawyers affiliated with Trump at the White House, and then after Trump left, to lie to the National Archives that it was just newspaper clippings and it wasn't anything significant. Then the reporting from the Washington Post is that when the National Archives wouldn't go away, that it was actually Donald Trump himself, Karen, who was the one who packed 15 boxes and kind of cherry picked the documents he wanted to return to the National Archives. I mean, just put that image in your head of Trump rummaging through documents and putting clippings and then putting some classified records to try to act like, oh, I'm returning some of them, and then asking other lawyers to continue to lie to the National Archives, and then eventually the Department of Justice, that all of these records were returned, which they were not. And then have Christina Bobb do a false declaration in June. Christina Bobb ostensibly is Trump's lawyer. She claims that she's not Trump's lawyer anymore and that she's just some news reporter who follows Trump around in rallies, which is a whole nother weird thing in and of itself. But she lies and says all of the records are returned, and she gives a red weld filled with some additional classified records. And then they conduct the search on August 8th, and lo and behold, there's a lot more classified records, including like potentially nuclear secrets in there, complete and utter violations of the Espionage Act, of obstruction. Like the timeline I just did that's the case. It doesn't get more complicated than that in my opinion there. So if I could just say one thing about the case. So if Donald Trump was found physically holding those documents, I would agree with you. But don't forget, these weren't found in his possession like that. They were in his domicile, they were in his office, they were in a place that he had constructive possession over. And so they need to put these documents in his hands as opposed to someone else, because he could have a defense, he could have a defense. What's her name? Christina Bobb, yeah. Yeah, Christina Bobb. She could say, I packed those boxes, I put them there. He had no idea who it was, who he had no idea what was in there. And so I wouldn't put it past some of his followers to fall on the sword for him, because they seem to follow him and will do anything for him, even put their own law license on the line. So really what the Department of Justice has to do is they have to put these documents in somebody's hands and figure out who removed them and who brought them there and who possessed them. And that's why context matters so much. That's why when they say in their appeal, it's not enough that we have our 100 documents or 103 documents. Our search warrant said we not only want to take the classified documents, but we also want to take the surrounding documents, what's with them, so that we can put into context what this is and try to figure out who might have taken these documents and who might have possessed them. So I think the same Washington Post article that you referenced talked about various aides of his, former aides, talked about him being a little bit of a hoarder, that he would just hoard documents in his private residence and in the dining room. And I just pictured his ketchup laden fingers, touching classified documents and having like fingerprints. The whole thought of this is a little bit strange to me, but you can imagine a scenario where classified documents are sandwiched in between his personal documents, which would make it even more, things that only he would necessarily have or he would necessarily be around. And it is that context, I think, that is needed to see what was commingled. They look at what was commingled with the documents to see who handled them, who mishandled them in the first place, and do a investigation to place these documents in either his hands or someone else's. So I do think there is a slightly more nuanced,
from a prosecution standpoint, they just have a little more work to do, not a lot. But the only reason it's not done is because of these delay tactics and because of the fact that these documents are now with a special master, and now Judge Cannon has extended the time period for the special, that Judge Deary tried to expedite this and said, come on, let's get this done. And it's his delay tactic, which is his number one legal strategy across all cases, that is hampering the investigation at this point. But I think as soon as the Department of Justice can do that, I think you're right. It's a straightforward case, and I think one that they'll, I guess it's a political decision after that, and whether or not to bring the case. And I know that I'm sure, I would guess that Merrick Garland's Department of Justice is thinking long and hard about the threats made by Lindsey Graham, that there'll be riots in the street, and a civil war, and all the other things that that his people are threatening if a case is brought. But really, if you don't bring the case, you're really sending the message that there are people who are above the law, and it's not fair. It's absolutely not fair.
I want to stress a few things here as well. One, how odd it is for a district court judge to overturn recommendations, routine recommendations that are made by a special master in any context. That's a very unusual thing. But in this context, the special master, Judge Raymond Deary, was the former chief judge of the Eastern District of New York. He sits on senior status right now, one of the most respected jurists, district court judges in the United States of America. And you have this newbie judge appointed by Trump overturning recommendations that reflect very sound judicial determinations. And not just judicial determinations, common sense, like Judge Raymond Deary saying to Donald Trump, hey, can you as the plaintiff just submit to me a declaration under penalty of perjury that these records here are either what was in Mar-a-Lago, or if you claim that these documents are suspicious, and like you claim for all the radical MAGA media that you go on that this is planted, hey, put that in a declaration under penalty of perjury so I know as the special master the full universe of records. And that's where Judge Eileen Cannon swoops in and goes, nope, he shouldn't do that. I don't want a plaintiff submitting an affidavit, only the defendant in this case. And the way this case is styled, because Trump brought it, asserting this lawsuit essentially against the Department of Justice for return of property and the injunction and all of those things. Judge Eileen Cannon stepped in and said, no, it should just be the Department of Justice who files the affidavit regarding the evidence log. So just weird things like that, which is what led to the Department of Justice to finally say enough is enough. We're filing this motion to expedite appeal. I think at one point the Department of Justice thought that they could live with Eileen Cannon. They've got the special master, as you mentioned, Karen, who's a respected person. Let's just go through the process. We got our classified records back, whatever. But she kept on making these horrible orders, and it was like, enough. The fact that the 11th Circuit granted this motion for an expedited briefing schedule, which is rare for them to do. Appeals take a very long time. It could take years for appeal. The fact that this is all going to be done now by November 17th is the end of the briefing schedule based on the order by the 11th Circuit is rare, but shows the 11th Circuit has a deep understanding, one, of Donald Trump's game playing, and also the national security interest to try to expedite it. And finally, what Donald Trump is really looking for, Karen, was you talk about this technical motion to vacate that's filed with the Supreme Court. I think there's one important piece, though, that is very significant. He wants access, and he wants to look at those classified records so that he knows what they are. And so one of the things he wants with the ordering that the Department of Justice put those 100 classified records back into the special master process is so he and his lawyers can look at it. And by the way, his lawyers, like who, Christopher Keiss, the lawyer who literally is a foreign agent of Venezuela, like who filled out a Foreign Agent Registration Act that he represents the Maduro regime. Like, you can't make up this weird Mad Lib fascist, like Trump's lawyer, who is a agent of the Venezuelan regime, would like our classified records back. But that's what Donald Trump is really looking for there. But there are those two separate things that are taking place here: the overall appeal, and then the what's now with the Supreme Court regarding the classified records that the Department of Justice has back. Although I'll leave you with this: the fact that Clarence Thomas, though, is requiring the Department of Justice to respond by next Tuesday, though, also shows that if he thought there was a greater degree of urgency in that request by Donald Trump, he would have made that deadline a bit earlier. But nonetheless, the fact that he's even requiring the Department of Justice to respond to this frivolous motion that was filed with the Supreme Court. I mean, Donald Trump is arguing that the 11th Circuit had no appellate jurisdiction, and he's arguing that this appointment of the special master was a non-appealable order by Judge Eileen Cannon, that she's basically immune from any appellate review. And meanwhile, she did grant an injunction stopping the Department of Justice from utilizing their own records, their own classified records, in a criminal investigation. Like, it's the most unprecedented ruling in the world, like in the history of the United States, that you just tell the Department of Justice you have to stop your investigation. But I digress there. Karen, any final points about the proceedings with the Mar-a-Lago search warrant case?
What do you predict Clarence Thomas is going to do?
You always have to think the worst with Clarence Thomas. I mean, the one thing that would restrain him, I think, here is that the 11th Circuit has a reputation for being a right-wing court, and him tying up the 11th Circuit, which ultimately makes a number of favorable rulings. I mean, you have two Trump judges on this, and this per curiam opinion, that the unanimous opinion that the 11th Circuit reached, overturning Judge Eileen Cannon before. So that's the factors that think maybe Judge Clarence Thomas will exercise restraint. But look, Judge Thomas is literally like married to an insurrectionist who is trying to overturn our government. And just as Clarence Thomas is talking about, banning contraception, and that he didn't want to stop at overturning Roe v. Wade, I mean, this is a rogue radical extremist judge. If I place confidence in a rogue radical extremist right-wing judge, I mean, that's not really the best place to put confidence here. But I do say that you go for it.
No, I was going to say, can I give you my prediction?
Yep.
My prediction is that he's going to rule in favor of the Department of Justice for the following reasons. This is such a limited, small appeal, and it's kind of inconsequential. It's not a huge deal, so that he can say, see, I don't always do Trump's bidding. I don't always rule, in his favor. I look at things correctly. And so that Trump and all his cronies will have something to hang their hat on to rehabilitate Clarence Thomas. That's what I think.
I think, I would never put too much confidence in Clarence Thomas not surprising us with, though, more corruption. But we will see. But ultimately, and this is the thing I've told everybody, his decision, though, is still revisable by the entire court. So if he goes rogue here, which would be truly rogue, I truly don't believe that, even as radical and extreme right-wing as the Supreme Court is, they would side with Judge Eileen Cannon's opinion here. And we've already seen what the 11th Circuit did in their per curiam unanimous opinion. There's a reason they did it per curiam. They wanted to send a message, and they used very strong language in their ruling, giving the records back, that it was self-evident. But let's talk about some other things going on before the Supreme Court. The October term has started, right? There's a reason that we've been quiet talking about Supreme Court rulings. The Supreme Court basically left us hanging in the last season, destroying our country by overturning Roe v. Wade and the separation of church and state, and the the Voting Rights Act, and you can go through the litany of horrible rulings this radical extremist court made by allowing the proliferation of weapons of war in the streets of cities. I can go down the list in their last horrific term, but they kicked this term off. A new face on the bench, Ketanji Brown Jackson, who made her presence felt and actually made some very, very compelling and strong arguments in the case that we're about to discuss. But the big case this week that I want to talk about is Merrill versus Milligan. This case involves a decision by Alabama, a Republican-led legislature, to gerrymander their 7 congressional districts to basically only allow one district to be represented by African Americans and have African American leadership in that district. The others were just so happened, and Alabama claimed it was quote unquote just trying to be race neutral, yet in a state that has 27% of the population is black, you only have one district that has actual black representation. And again, Alabama said, oh no, we're just being race neutral. But Alabama made an even more, in my view, outlandish, but an argument to try to just completely repeal the Voting Rights Act of 1965. And they basically argue that Section 2, which prevents discrimination in voting, that Section 2 is itself a violation of the Equal Protection Clause of the 14th Amendment. In other words, trying to stop racism, Alabama argued, is racist. And that trying to help and assist in dealing with systemic racist issues that exist, to even think about addressing that, reflects an evaluation of race, and that violates the Equal Protection Clause of, they don't say this part out loud, but obviously what they're saying is you're violating the equal protection of white Alabamans. And that's a very dangerous precedent. Now, the Supreme Court, who heard oral argument, was a little bit skeptical of those claims that Section 2 itself was a violation of the Equal Protection Clause of the 14th Amendment, but the radical right MAGA extremists on the court seemed like they were willing to uphold the Alabama gerrymandering scheme. And you go back here, Karen, for the past 20 years plus, the Voting Rights Act of 1965, even a little longer, has been under attack by MAGA extremists and the precursor to them, radical right extremists. You have the Shelby decision from 2013, which essentially revoked the pre-clearance requirement. Section 5 of the Voting Rights Act provided that you needed Department of Justice approval or a district court panel's approval if you were changing up your electoral map and doing the gerrymandering to approve it, that it wasn't a racist map. What the Supreme Court did in this Shelby case in 2013 is they didn't say that Section 5 was unconstitutional, but what they said was that the formula for how you determined a Section 5 analysis, which was embedded in Section 4, that formula was unconstitutional to determine where preclearance should apply, and that therefore the effect of that was to basically revoke or remove preclearance. And so that is why what we've seen here, without preclearance taking place, states have put forward racist gerrymandered maps. And whereas before the burden was on the states to justify their maps and it had to be pre-cleared, now the burden falls on civil rights groups to have to file affirmative lawsuits, which could take a lot of time. And as the time inches closer to an election, as it works its way through the court, what the Supreme Court has basically said is, too close to an election. And if it's too close to an election, the presumption is going to be, let the racist map stand until we have an overall oral argument until after the election. Well, the damage will then be done. And that's what's happened in Alabama. But now they're addressing this racist Alabama map, which the radical MAGA extremists on the court seem okay with that map. But the argument was one to try to even push it forward further and abolish Section 2, which prevents discrimination in gerrymandering processes. Karen, what else do you think is going on here? And by the way, I thought Ketanji Brown Jackson's argument here, when she was speaking, was great. She goes, the 14th Amendment and the Voting Rights Act are not race-neutral pieces of legislation. These pieces of legislation and the constitutional amendment addressed a problem of systemic racism in this country, and it tried to address it. So for you to say that the thing that tried to address it is racist and that we should be race neutral and look away and blind our eyes to the reason that we have the Voting Rights Act and we have the Equal Protection Clause, you are twisting and contriving this to support the exact opposite ends of the constitutional amendment and this major piece of legislation.
Yeah, so I think, look, you said it beautifully, but I think that the critics of this, the critics, or I should say the supporters of this law, the people who, the people in Alabama who are trying to keep their gerrymandered districts the way they are, basically is saying that this is racism. You're asking us to consider race to create these voting districts. And so that in and of itself is racist. You're supposed to be race neutral. We're supposed to level the playing field. We're no longer obsessed with issues of race. Slavery was a long time ago, time to move on and be colorblind. And those are the kinds of arguments that they put forward. But I think, as you said, Ketanji Brown Jackson really leaned into this in a beautiful way and reminded people that the whole point of the 14th Amendment, the whole point of the 14th Amendment was to make whole former slaves. The historical record established that the founders, of this country, who created our nation and created the Supreme Court and created, the rights, were all white men. And so when you think about it, I think 5 out of the 9 Supreme Court justices today, whether they're because they're women or Black, would not be able to vote today, if you really want to just look at the history of the Constitution here. And so there have been lots of laws, including the Civil Rights Act of 1866 and the Voting Rights Act of, I think, 1965, and the 14th and 15th Amendments to the Constitution, all trying to address the issues of inequity and of these freed slaves called freedmen who were not treated equally, and they weren't treated equal to white people. And so the whole point of many of these laws and constitutional amendments was to try and elevate the status of these freed slaves, these freed men, so they could be brought equal to whites. So I thought, she really leaned into the issue of race and said that it's not race. It's not the goal isn't to be race neutral or blind, that's not what's required or even the goal. The goal is to recognize unequal treatment and to elevate people who are treated unequally so that they can have the same rights as everybody else and try and eradicate discrimination in this country. And it's just amazing to me that whether it's in laws like poll taxes or, all the things throughout history that have tried to suppress voting in people of color, and today it's going to, history is going to look back to our last election and say, oh, it's all this talk of mail-in ballots, and or computerized ballots, and all the things that the Republicans are trying to outlaw today. There's always been efforts in voter suppression, and it's always geared towards minorities and people of color. So you can call it whatever you want to call it. It's always, they call it different things. And now today it's the gerrymandering in Alabama. And I think that it's really important to recognize that these laws exist to try to level the playing field, because the unfortunate and disgraceful history of our country has been to always try and put down people of color. And until we recognize that and we embrace that and try to correct for it, I think we are going to run the risk of either suppressing or diluting Black votes in this country. And that's exactly what the argument, I think, that's happening here.
There was a moment during the oral argument as well where Justice Alito was like, well, if these factors are met and you're able to show the populations of the majorities in certain areas are met in these southern states, wouldn't the plaintiffs always win? And wouldn't that be unfair? He made statements to that effect, and it was like, no, what's unfair is that their representation is being taken away from them. That's what's unfair. And what he didn't recognize in his statement was that he was acknowledging, or maybe he did, but he just, contorted the own argument. He was acknowledging, yeah, the problem is in southern states like Alabama, like in this specific case, if you have a 27% population is black, yet they're only represented in one congressional district, that is problematic. And to say that they should have additional districts to be reflective of their actual representation, he views that as like an unfair advantage and a win. No, what's unfair is that African Americans were enslaved in our country and they have unfair advantages, and there's systemic racism in our country, and that these laws that were passed try to address that, to precisely address the problem that we're seeing here in Alabama. Like, this is a case that if there was pre-clearance, wouldn't even be a close call, Karen. I mean, like, just look at the numbers. 27% get one congressional district. That's absolutely insane. That's the exact problem why there was the Voting Rights Act of 1965, to specifically address a situation like this.
This just goes to show how important the census is every 10 years. The census, sometimes people get annoyed by it. It's quite expensive. It takes a lot of time, and you have to knock on doors and try to count people. And the 2020 census was a challenge because of the pandemic, and COVID, and people weren't going to open their doors to strangers, et cetera. But this goes to show how the census is such an important part of our history, because the 2020 census is what demonstrated that Alabama is the 27% black of their voting age population. And it's what allowed this particular scenario to come about, because it showed that given the numbers that exist, they should have 2 voting districts and not just 1 out of the 7. So this is why things like the census is such an important part of our history and our tradition and our laws, and people need to participate, because it's really the only way that you can fight for equal representation in areas like this.
Oh, couldn't agree with you more. And then you can't also ignore the fact that the Supreme Court had previously made rulings regarding the census, cutting it off, I think, prematurely during 2020. It's a whole nother conversation. We'll cover that in another Legal AF, but the whole census process was co-opted and corrupted by Donald Trump. Still have a lot to talk about here on Legal AF, but I want to talk about our next partner. It's Bombas. Bombas' mission is simple. Make the most comfortable clothes ever and match every item sold with an equal item donated. So when you buy Bombas, you are also giving to someone in need. Bombas designed their socks, shirts, and underwear to be the clothes you can't wait to put on every day. Everything they make is soft, seamless, tagless, and has a cozy feel. There's a pair of Bombas socks for everything you do. They come in tons of options like comfy performance styles made with sweat-wicking yarns, which means your feet stay cool while the rest of you works up sweat. Bombas no-show socks are designed for comfort while being specially engineered to never fall down. So let your ankles be free to soak up the sunlight. Bombas t-shirts are made with thoughtful design features like invisible seams, soft fabrics, and the perfect weight, so they hang just right. And Bombas underwear is so breathable and fits so well, it feels like you're wearing nothing at all, in a good way. And did you know that socks, underwear, and t-shirts are the 3 most requested clothing items at homeless shelters? That's why, and this is so important, Bombas donates 1 for every item you buy. And so far, Bombas customers like you have helped donate over 50 million items of essential clothing. Go to bombas.com/legalaf. That's BOMBAS.com/legalaf. And use this code LEGALAF, LEGALAF, for 20% off your first purchase. That's BOMBAS.com/legalaf and use code LEGALAF at checkout. Bombas.com/legalaf, code LEGALAF, and get that 20% off your first purchased. Switching gears here, I want to talk about the Elon Musk potential settlement. Apparently, he's ready to settle with Twitter. He was on the verge of going to trial in the Delaware Chancery Court. The settlement is certainly, he's not getting a discount. He has to buy it for $54.20 a share if the settlement goes forward, as it's being reported. That's still the $44 billion purchase price that he initially said that he was going to pay before backing out and leading to the lawsuit. As he was approaching trial, there was a number of pretrial rulings that were against him. First, like Trump, he wanted to delay, and the Chancery Court judge would not let that take place. There was a number of other pretrial rulings that did not go in his favor. He was asked, and he was ordered rather, to hand over files about potential investors in a $7 billion equity raise as part of the deal. In late September, the judge denied Musk's demand for additional documents about Twitter's internal measure of robot and spam accounts. In other words, the judge was not buying his arguments that he backed out because of the bots and the spam and all of that he was claiming. And one of the things that the judge recently allowed, remember that whistleblower, Karen, who had fortuitously emerged and made the claim that he was aware, he worked for Twitter, was a hacker, and said that he was aware of all of these bot accounts and claimed to be a whistleblower. May have been a whistleblower. I don't. What the issue is that Twitter basically said that's a little bit suspicious here. The timing's a bit suspicious. I think that Elon Musk is behind it. And the judge allowed discovery to proceed into those areas as well. Elon Musk had to turn over additional records. The judge was very critical of Elon Musk and his lawyers and just how they've conducted themselves in discovery. And it did not seem like Elon Musk was going to win this trial. It seemed like he was going to have a very, very, very significant loss. And so I guess to cut his losses, he's claiming he's going to proceed with this acquisition. Although with Elon Musk, it's all games. So you never really know until you know. And it's possible that it's just a delay tactic. The settlement won't materialize like they're supposed to, and then they try to delay the trial. So I think you have to be very careful strategically here if you're Twitter and how you approach this potential settlement agreement. You got to make sure it's real. And with Elon Musk, you don't know if he's actually trying to set up his own bankers, or there's a lot of questions here about what led to this settlement. I can say from a standpoint of Twitter, I think it would be very problematic to have Elon Musk control Twitter. I think he, just the way he's even conducted himself with this acquisition shows a lack of empathy, a lack of caring, a bully, someone who's willing to dispose of not just Twitter employees, but of the communities that have developed. And I think it is very important. And this is one of the things that the radical right-wing extremists try to do. But it is important for me to have social media platforms that have certain common sense forms of moderation where I don't want hate speech. I don't want Nazis. I don't want to have to go on and see people, hate, spreading hate and Nazis and spreading Putin propaganda and disinformation about pandemics. Like, that type of stuff is problematic. And, if Elon Musk allows all of that to take hold of the platform, I think people are going to run for the hills, quite frankly, because you just look at what the Truth Social app is like. I mean, it's filthy. It's all QAnon stuff. And it's like, you think about just going to a public square or a public space, or, there are limitations to what you can do. And then you think about going in a private space, though, or going in a mall. And then, people like spitting on your food and yelling at you and giving you the middle finger when you're just trying to interact and have, normal, appropriate conversation. So anyway, that's my analysis of the law, and there's my personal feelings.
What do you think? So my understanding was that Elon Musk was set to be deposed right before the trial as well in the coming weeks, which seemed like a really short period of time between deposition and trial that's supposed to start October 17th. Do you think that's part of the reason he's saying that they're going to enter into potential plea so that he could delay his deposition and delay the trial? And then that way, as you said, maybe the whole thing falls apart, but at least then he's not forced to be deposed right now or to go to trial right now.
Yeah. I think that's the short answer is yes. And the longer answer is he's probably a very difficult client to manage as well. And there's a great degree when you're dealing with him, though, of bad faith, of obfuscation, of vagary, and trying to game the system. And so we're not dealing with, in a litigation, his view of things. He would say he is a rational actor who acts irrationally to try to take advantage of situations. And so, you just have to be very cautious dealing with him.
Yeah, no, this is definitely one to watch. I have to say I'm slightly disappointed in Twitter why they're pushing this. It's because I think it's the end of Twitter, but who knows? I'm sure they have their reasons why they're pushing.
Well,
this
I think they have a lot of money. The reason is money. I think it's that simple. The share price, whether it trades in the 30s, 35 range, Twitter has not done a good job monetizing their platform the same way Google has with YouTube and other social media platforms are. And so I think you have directors there who believe they have a monetary fiduciary obligation that the stock price is never going to go higher than 54.20. And Elon Musk picked 54.20 because it has 420 in it, and he thought it was funny. And I think if you're a board of director on Twitter, you're thinking we're never going to get higher than that, or it's going to be incredibly high. And a lot of our investors will get an exit. Remember the people who are on the boards of these and the people who are pushing for these are shareholders, and usually institutional shareholders who want a return on money. And they're going to make a lot of money from this transaction. But to your point, Karen, they've really kind of sold out. Not really. They did sell out the community on Twitter. And I think it will lead to the inevitable destruction of Twitter, although I would not like that to be the case. But I do think when you are a platform like Twitter, or you do have, and you are a public company, I guess it is upsetting sometimes to see them view it so crudely when they do play an important function in discourse and in communications, for them to just sell out this way. But nonetheless, that's the situation. We'll see what happens. But, it's why we at the Midas Touch Network make sure that, there are lots of groups that we're really big on Twitter, or we're really big on TikTok, and we're really big on just one of these, but not the others, right? What we've made our mission is being really big at connecting with a community of people, real people, and having communications and connecting. And so the Midas Mighty is always the secret sauce of the Midas Touch Network and Legal AF. And that's who supports this. So no matter what social media platforms exist today or exist tomorrow, the most important thing is that there's a real vibrant pro-democracy community out there. And that's one of the things I love about the Midas Touch Network. Now, one of the other important things I want to mention before talking about the final story is, I don't know if you know this, Karen, but we just got a Patreon website at patreon.com/Midas Touch. That's patreon.com/Midas Touch. We're not funded by any outside investors at all at the Midas Touch Network. But if you want to help grow the Midas Touch Network, we're fueled by democracy and powered by you. No matter where you live in the world, you can join a membership tier with exclusive benefits at patreon.com/Midas Touch. And also check out store.MidasTouch.com for the best pro-democracy gear. That's store.MidasTouch.com for the best pro-democracy gear. Finally, we are gearing up for the next January 6th committee hearing, October 13th. Be there or be square. People still say that, Karen. Is that like a dorky expression? Be there or be square.
That's okay.
But we will be, of course, doing a live stream, as we always do. We're one of the top viewed live streams for the January 6th hearings, live on October 13th here on the Midas Touch Network. Anything you're looking forward to, Karen, coming up with the October 13th, January 6th committee hearing, or in general?
I'm hoping that it's a blockbuster. I'm hoping that they're saving the best for last. I'm dying to know what Ginny Thomas said to them. And I'm really hoping that they're going to link even more so directly the insurrection of January 6th with Donald Trump. Because so far, these hearings have not disappointed, and they have exceeded any expectation I had of them. I really think that they have served such an important part of just creating a historical record for future generations, because, you know, the January 6th insurrection was such a significant day. You know, I was talking to someone last night about these hearings, and they said, you know, do you think anything's going to really come of this? And I said, well, what do you mean by that? You know, what is the purpose of these hearings, and what do you expect to come of it? And I think that's one of the things that people are looking for, is what will come of these hearings. Will there be a result given what happened? And so, you know, I found myself explaining to this person, well, really, I think a lot has come of these hearings. Number one, I think the House did their job by holding these hearings, and so creating a historical record, as I said, for future generations, just so that people know exactly who did what. You know, they interviewed thousands of people, and there is a record of what happened on that day. And there's also been lots and lots of prosecutions. You know, I think we're up to 800 or 900 at this point. And so that to me is one really important part of it. Another important thing that these hearings have done is there's a lot of people, and you know, I hate to admit it, but myself included, after January 6th and after Trump, so many of us I was traumatized by the whole Trump 4 years, as well as the January 6th insurrection, that I was so relieved that Joe Biden was our president, that I just kind of felt like, let's just move on. You know, let's just move forward, put this past us, think about this as like just this ugly part of history, and let's just move forward. I don't want to think about it. And so when the January 6th hearings came about, part of me was like, why are we bringing this up again? It's like an ugly, you know, part of our history. Can't we just move forward? And I will say, I think I was dead wrong about that. These hearings were incredibly powerful and significant. And really, you know, the people like me who thought, can't we just move on? We shouldn't just move on. And we need to really understand what happened, how significant it was, how close we came to civil war and to a coup and overthrowing democracy in this country. And until we understand it and really understand how important that was, and how much there are still a group of people in this country, a large group of people in this country who continue to feel this way, I think, you know, there's a risk that this could happen again. And so I think the hearings have done an excellent job at really showing people like me who didn't quite understand the insidiousness of the problem. It wasn't just this bad day, you know, it's a whole, you know, from the day Donald Trump became president and started filling federal judges, filling spots on the federal bench with Trump supporting judges, you know, that he recognized right away how he's going to infect like a bad virus every branch of government, every part of government, whether it's state and local races and supporting these candidates to get the state governments and the state legislatures filled with MAGA Republicans, to the judicial branch and all the judges, and to, as you always talk about, this misinformation campaign that he espouses. And I think the January 6 hearings have done an excellent job at just showing how insidious this entire conspiracy to take over the country has been. So to me, those are two really important things that have come of this. But I think what a lot of people are looking for is handcuffs on Donald Trump. And that's what they want. They want him to be arrested. And I kind of hope that, that's the one criticism I have of these hearings so far is somehow there is that kind of missing link, between all of this and him directly. There's a lot of circumstantial evidence, but I would love to have the smoking gun. But I do think that whether it's Fani Willis, in Georgia with Find the Votes case, or whether it's the Southern District taking, the call to action from Tish James and the criminal referral that she's giving them, or whether it's the Mar-a-Lago case that we talked about first with the classified documents, or January 6th. I'm hoping one of them will come of this, but I do think that the January 6 hearings have been extraordinary, and I'm hoping that since this is Liz Cheney's last or close to last hearing, hopefully, I don't think she'll disappoint. I think it's going to be a blockbuster like the rest of them have been.
The January 6th committee hearings, though, I think also injected like a booster shot of democracy at a time when we needed it the most. In addition to the proceedings that were taking place, I think it just injected a sense of energy and passion and a rallying call for democracy. And we've always framed the issues here at the Midas Touch Network as pro-democracy, and that this is a pro-democracy network and community, which includes Democrats, independents, and people who still may identify as Republican, but not MAGA Republican, and people who are leaving and feel like they are partyless at this point. But it's all under the rubric of pro-democracy. And I think the theme and the message that has pervaded all of these January 6th hearings has been the importance of our democracy. And there are people and Republicans who testified, mostly all Republicans testified, right? 98% of all of the witnesses who testified were Republicans. But you saw a difference between a Republican who we could have policy disagreements with, but who support our Constitution. And then you saw, as you said, Karen, this new strain of MAGA fascism that, like a virus, spreads its tentacles and tries to infect each of our institutions. And that's why we do this show, Legal AF, each and every week, and have the midweek episode as well, because it is so vital to empower you at home or wherever you watch this with this knowledge to understand these legal cases and their implications, so you can be ambassadors for this unapologetically pro-democracy movement. Karen, it is a pleasure spending this time with you for this special midweek edition. Well, it's special because you and I are doing it, but there's a normal midweek. This midweek edition of the Legal AF podcast. Everybody, make sure to go check out our Patreon website at patreon.com/MidasTouch, patreon.com/MidasTouch. Now's the time to also check out store.MidasTouch.com. If you are watching this on YouTube, please make sure you hit the subscribe button now, and do me this one other favor. Wherever you get audio podcasts, make sure you download this and subscribe on the audio podcasts. Play it on the audio podcast. You could re-listen to it as well. It helps with the algorithm there. So make sure you check that out on the audio and leave a 5-star review, will you? It takes you 2 minutes to leave a 5-star review. And it's so great and always warms my heart when I see those good reviews and honest reviews. If you have criticisms, I could take them. So send them as well, whatever. But leave a 5-star review. And I want to thank our sponsor again, Bombas, bombas.com/legalaf. I wear Bombas, and I know you do too, Karen. So it's great to have them as a sponsor. Again, check out bombas.com/legalaf.
Ben, let me just say one thing before you sign off. Bombas really are better socks than any other sock. They are exceptional. And if you're on the fence and you're looking for a new pair of socks, these are your socks. And it's great that they donate a pair, but that is not the main reason, I think, to buy them. I think they really are better than every other type of socks. They don't bunch up. They don't fall down. They're more comfortable. They hug your feet beautifully. And I know this is totally off script, but I've been a Bombas wearer for many, many, many years. And I always get them as gifts for people because I do think they are that much better than all the rest. So I highly, highly recommend them. That's all I want to leave you with.
That's a great way to leave the episode, Karen Agnifilo. Appreciate it. I'll see you next time on the Legal AF podcast with Midas Touch. I'm Ben Meiselas, joined by Karen Friedman Agnifilo. Until next time, shout out to the Midas Mighty.